Okay, should we go ahead and get started? Do we have everybody ready? Hi, everyone. I'm Kate Kilberg. I'm one of the partners at Catalyst Law, and welcome to our presentation about employment benefits and employment law during the time of COVID-19. We had originally scheduled this presentation with one of our Catalyst lawyers, David Rocker, who does employment litigation. But David, unfortunately, is sick, and so we're lucky enough to have Kate Watkinson Wright from Watkinson Legal join us to give us a little bit of an update on employment law issues during this global pandemic. So thank you so much, Kate, for agreeing to pitch in at the last minute. And then we also have, we're proud to have Kristen Cooper, who is from Blackbird Benefits Collective, to give us a little bit of a perspective, give us perspective on these issues from an HR provider. So I'm going to go ahead and just give you kind of our initial housekeeping announcements, and then we'll turn to our presenters. So first thing is just to clarify that this presentation webinar is intended to be educational. We're not going to be able to give specific legal advice on this webinar, but we will do our best to answer questions that you have. And I want to point out to each of you of our attendees that we have a chat box on the right where you can type your questions. I will try to get to those as you type them in, but we may end up reserving some for the very end of the presentation. We have planned for some Q&A time at the very end. So if you want to hold your questions till the end, that is also okay. And with that, I'm going to turn it over to Kristen from Blackbird Benefits, who's prepared a lovely slide presentation for us today. And we'll get going with Kristen's presentation. Thank you so much, Kristen, for being with us.
So much for having me. Hi, everyone. I'm Kristen Cooper. I'm with Blackbird Benefits Collective. We are a B Corp employee benefits agency. And I wanted to just go over some of the key things impacting employee benefits in the light of COVID-19 and just some kind of reminders. I know you're probably flooded with information as much as I am. Coming from all different sources. So I'm hoping to just kind of give a nice little overview of the key things to be thinking about. So Meg, I seem to have lost my presentation. Is there a way to get that back? There it is. Okay. Okay, so a couple key pieces that happened here. So on March 18th, the Families First Coronavirus Response Act was signed into law, which has impact on the, sorry, you can't see that. The key pieces of that are it requires employers with fewer than 500 employees to provide 12 weeks of Family Medical Leave Act leave for childcare reasons related to COVID. The new FMLA leave needs to be compensated for after the first 10 days at 2/3 of an employee's wage, up to $200 a day. And then they must also provide 80 hours of paid sick time for specified reasons related to COVID-19. The other piece is the CARES Act that was signed into law on March 27th, which has the bigger impact on employee benefit programs. So the biggest thing with the CARES Act is it requires health plans to cover both treatment and testing for the coronavirus at 100%, and that includes out-of-network providers. So people have access to care no matter where they can go or anywhere that they can get a test or treatment. For high deductible health plans with a qualified health savings account, they can now cover telemedicine before meeting the actual high deductible of that plan, and that's a qualified expense now too. So trying to help people access care while staying at home. Most of the insurance companies are still directing their members to have them call their primary care provider as their first point of contact if they are having symptoms of coronavirus. So starting there and trying to have them direct their care, or if they don't have a PCP, they can try calling an urgent care center before actually going to visit one, so they can let them know where they can go to find testing. One of the big implications with the CARES Act is the impact on flexible spending accounts and health savings accounts. So one of the big changes there is that it is now going to allow reimbursement for over-the-counter medications and menstrual products as eligible expenses. So for the OTC item, those were previously something that had to have a doctor's note. So even if you were getting something like cough syrup, you needed to have a doctor's note to be able to submit that for reimbursement. So now they've made this retroactive to January 1st, that the over-the-counter products, and again, the menstrual care products, are eligible for reimbursement. A couple things to note on that. It's retroactive, so you can go ahead and submit a paper claim for that. So if you've had those expenses and you have your receipts, you can go ahead and submit them now and they'll be reimbursed for that retroactive time period. They're not going to do any kind of an automatic reprocessing of anything that's been submitted and denied so far, but you do have a new opportunities to submit that expense. The other key piece to note is that your debit card, if you have a Flex account or the HSA, the debit card feature probably won't work for another few weeks. So what happens is that there's vendors that provide the merchant codes that tie into everything. So when you purchase a product and swipe your card, it can recognize that it's an FSA expense. You'll often see that noted on a pharmacy receipt or something like that. But it's going to take them a little while to go ahead and update all the systems to reflect all of those products that are now going to be available. So until we get further notice that that system has been updated and is fully up and running, you'll just need to do paper claims for that. And then that is going to require an update to your summary plan descriptions. It's not going to be a huge ordeal, but it'll just typically be an amendment saying that these products are now eligible for reimbursement without a prescription. And you'll want to just notify your employees and make sure you're communicating to them that these are now things that they'll be able to use their funds for. The other side of that is the dependent care account for the FSA. So with what's happening right now, this does create an opportunity for a mid-year election change if your child care needs have changed. So for instance, if you're now working from home and don't have the need for childcare, you can adjust your dependent care reimbursement to reduce the amount that you're currently taking. For some people who maybe they're essential employees that actually have to work different hours and have a different need for healthcare now than they previously had, that creates a window for them to go ahead and adjust their election accordingly as well. So the big thing there is that the election change needs to really correspond with the type of situation that you have. One thing I'll mention that is a little bit up for debate is some of the flexible spending account administrators are saying that a medical care need change due to the coronavirus is a qualifying event to make an adjustment to your flexible spending account on healthcare. Other administrators in the same breath are saying exactly the opposite of that. So I think it's down to a little bit of interpretation. The two I'm mentioning off the bat are Task and Health Equity, which are two pretty common providers. But I would suggest talking to your tax attorney and your advisors and determining which version of that you are most comfortable with. Task errs on the side of being very pro-participant, which is wonderful, but it's just a matter of getting the advice specifically for your business that you feel the most comfortable with on that. Moving on to the Section 125 rules. So if you are allowing employees to pay their health insurance premiums on a pre-tax basis, it needs to comply with the irrevocability rules of Code Section 125. So what that means is employees make their elections before the first day of the plan year, and those are locked in for the full plan year unless they experience a mid-year qualifying event. The other piece of that is an employee who does not elect coverage during their open enrollment period or when they are first newly eligible as a new hire, they then also have to wait until that following open enrollment cycle before they can make an election or enter the health plan. But what's happening right now, there's some other limited circumstances for when an employee can make changes. So one of those qualifying events would be a change in employment status. So for instance, having to take a leave of absence or no longer being eligible for benefits, that would be a qualifying event for a mid-year change. Significant change in health plan coverage, or a special enrollment event such as marriage, divorce, birth of a child, and so forth. So those are typically the common things that we find as an applicable event for a mid-year change. So whether an employee's COVID-related election change would satisfy the IRS current rules is unclear entirely, and it's going to be based on the specific facts involved, really on a case-by-case basis. And it's also not clear whether the plan changes made by the CARES Act, so the requiring of testing and treatment for COVID, considers itself a significant enough change for the health plan to then also warrant a mid-year qualifying event. So in some cases, one might say that, yes, it absolutely does if someone is taken ill and is suddenly, needing an expensive course of treatment or that kind of thing, and that's now an available benefit that they previously wouldn't have had. That seems like a significant change in my mind, but once again, best to consult with your own advisors and go from there. Let's see. One of the other things that's happening, some employers are offering a special mid-year enrollment window. So due to this health crisis, some insurance companies are allowing group health plans to offer a special mid-year enrollment to allow people to come in and elect coverage if they had not during their election window previously. This is something that you'd want to run by your specific insurance company and get buy-off before you communicate anything to your employees. And then again, that ties into the considerations around the Section 125 rules for pre-tax premiums and determining, what's really allowable entry into the plan tying to a pre-tax premium in this particular situation. So definitely get buy-off from the insurer and talk to your tax advisor about what type of change that you're looking to make. A lot of employers are experiencing employment changes, so they're dealing with different provisions of layoffs, furloughs, and again, not all of these impact eligibility for coverage. So it's all going to really vary between what kind of plan you offer, if you're fully insured or self-funded, a lot of different facts, what group size you are, and so forth. So once again, just my last caveat on that is to work with your tax and legal advisors before you make changes and open up your health plan to inviting people in who were not previously enrolled, and just making sure that you've got everything in place to substantiate that kind of a change. The action items, if you are looking to do this, so once again, determine if the newly enrolled employee's premium will be paid on a pre-tax or after-tax basis. So there is the possibility of allowing them to enroll but not taking it on a pre-tax basis because of the Section 125 rules. That all gets a little bit muddy. But reviewing your plan documents to determine if an amendment is necessary. So some of the plan documents put out by the insurance companies are pretty vague in the specific language around eligibility, and just kind of refer you back to per the terms of your employer's eligibility provisions, you will enter the plan at X date, and it doesn't particularly call it out. So if you do have plan documents that are very specific in saying that, employee A is eligible on X day following 90 days or 60 days of employment, then you need to go ahead and update that to indicate any special enrollment periods that you're going to be offering. And then you'll want to make sure you can communicate the special mid-year enrollment window to employees on a broad basis that lets everyone know what their options are, the time frame for coming into the plan, and what the implication will be for them on a premium payment basis. So then getting into what happens to benefits during a layoff or a furlough. So furlough versus layoff, a furlough is typically an unpaid leave or reduction in hours where the employee remains an active employee. So they're not necessarily drawing a paycheck, but they are considered an active employee on your plan. A layoff involves actually terminating the employee from employment with the potential to rehire them later. So the furlough can reduce the overall payroll costs while still maintaining some protection for employees. And in some cases, it can make them eligible to file for unemployment, depending on their particular situation. So in some cases, people find a furlough is a better way to reduce some costs for a short-term period with a greater potential to keep those employees in place and bring them back as soon as there's a possibility for them to return to a full work schedule, and also avoiding the disruption and transition of onboarding new hires and going through that entire process as well. So then when an employee is laid off and they are no longer meeting their eligibility requirements, they need to be offered COBRA or state continuation. So if you're an employer with 20 employees or less, you are subject to the rules of state continuation, or what we call mini COBRA. If you have 20 or more, then the full provisions of COBRA do apply. So even if you are going to pay for benefits while someone is while someone has been laid off, and you're saying, we'll go ahead and pay the first 2 months of your COBRA coverage as a result of this layoff, you still need to move them over from from active to COBRA status on the health plan. And then typically, if an employee is then reinstated within the specific time frame that is outlined in your plan document, then they're usually reinstated to active coverage without being required to reserve any kind of a waiting period. So the employee options during a layoff. If the employer does not pay for COBRA coverage, you have a couple of options. You can go ahead and elect COBRA, knowing that you'll be paying the 100% of the cost for the premium on your own, out of your own pocket, at the current level of benefits that you were offered. Or this also creates, because you've lost eligibility for your health plan, this also creates a special enrollment opportunity for the marketplace, so the healthcare.gov type of plans. In that scenario, you might actually pursue just to see what it looks like to get one of those plans. In some cases, if you don't need a lot of healthcare expenses and your employer offers a pretty robust plan, then perhaps you can find a less rich plan for a much lower premium. And then depending on your income situation, family structure, that kind of thing, you might actually qualify for some subsidies as well. So there might be some ways there to continue a level of coverage that's more suited to what your personal needs are. The other side of this is that if you are laid off and the employer is continuing to subsidize your COBRA, either they're paying for all of it for 2 months, or they're saying, we'll continue what we've paid in the past and you'll pay your employee cost share to have this coverage. At the end of that 2 months, when you are now newly subject to paying 100% of that whole COBRA premium amount, that then also creates a qualifying event to get out into the marketplace and potentially find a more cost-effective plan for you. And then one other thing I wanted to touch on are disability claims. So what we're seeing from most of the carriers out there, and again, you'll want to check with yours specifically, but if an employee is under quarantine but they're not ill, then they are not going to be meeting the definition of disability to be filing a short-term disability claim for income replacement. But if the employee should unfortunately become ill at some point down the road, then at that point in time, the claim will be evaluated and it will be treated like any other illness. One of the big important features about disability coverage is the actively at work provision, meaning an employee cannot be out on a leave or anything like that. When they file an actual disability claim, they need to be considered an actively at work, even if it's a day off, a weekend, et cetera. They are generally speaking an actively at work, fulfilling the normal duties of their role. But with this situation, if an employee is away on leave or been furloughed or that kind of thing, the carriers are typically treating that as still being actively at work for the purposes of filing a claim. So Again, that's something that you'll want to check with your specific carrier about, but hopefully your employees are not faced with this situation, but in the event that they are, that coverage will hopefully be available. And then some reminders as well, just once again, health plans have to cover the treatment and testing for COVID-19 at 100%, including out of network. Employees need to be going through either their PCP or customer service to have them facilitate where they're going for testing and treatment. We're really trying to encourage people to communicate the mail order benefit to their employees and have them get signed up for that if they are taking maintenance medications, something that they're, taking on a recurring basis to treat a condition. Typically, they can get a 90-day supply sent to their home, so that can help support them staying home, staying safe, staying healthy. A lot of insurance companies also provide a discount for doing the mail order service. So in some cases, you can get 3 months supply for the price of 2. So it's a great way to save some money during this time as well. Talking to people about the expanded access for telehealth services as well. So a lot of the carriers have expanded what is available through the telehealth benefit to include a much broader scope of behavioral health services, which are typically covered at a much lower copay than even an office visit. So trying to provide more access to care to meet people where they are right now, which is typically at home, and trying to just provide more mental health support, especially during this time of stress, anxiety, worries, that kind of thing. People just have a lot more available to them that they might not know about. And then also communicating repeatedly. I feel like the EAP is the least remembered benefit out of most benefit packages, but just reminding people, even on a weekly basis, if you offer an EAP plan, where to go to access it, that it's free, that there are, a number of visits covered, either that are typical now virtual care, for each issue that they're facing. So if one issue is financial, they've got someone to talk to for a set number of visits for that issue. If there's something else going on that's a family issue, they've got, a separate visits for that. So they can really get a lot of mileage out of these types of programs. If you're a small business, you probably have it baked into one of your health plans. So if you have coverage through someone like Regence Blue Cross Blue Shield here in Portland, all their small group health plans have a 4-visit EAP program baked into all of their plans. So, and again, that's 4 visits per issue that you're dealing with. So that's there and available. Some of your other benefits, such as your long-term disability coverage, if you offer that, a lot of those have a small EAP baked in as well. So it's just kind of sitting back there behind the scenes a lot of times. And then if you don't have one, but you feel like maybe you would like to offer one, it's really easy to implement a freestanding program with a local provider. There's some really, really good ones in the Portland area that just do a phenomenal job of helping people find care, helping people find care that's either close to them at home, close to a family member. They can also do a lot with assisting people with elder care, referrals, and that kind of thing, which is just a lot to be juggling all at one time. So I can't stress enough communicating those kind of services that are available to ease people's worries and stress levels right now during this period of time. And again, just getting back to the Regence coverage, because I feel like it is so prevalent for small businesses out there. They have also just partnered with Dispatch Health to bring urgent care home health visits to all of their members. So this is pretty great because you can call in and get it set up and have someone come to your home, typically in the space of just a couple hours. The bummer is that they cannot do testing or treatment for COVID-19, but they can address all the other issues that might pop up. So if you are out in the garden and tend to be a little bit accident prone, like somebody might be, and you end up banging yourself up somehow, you can go ahead and have someone come to your house and get you fixed up without having to actually leave and go into a medical center. So same thing, like kids getting hurt, all those kind of things, you can get a little bit more urgent assistance in your home during this time. And yeah, lastly, I can't stress enough just communicating over and over as much as possible what's available to your employees and how to access it. So oftentimes we communicate, but people, wherever place they are in this world right now, they can only take in so much information. So sometimes it's there, it's been put out there, but just keep communicating just what they have available to support them during this period of time. I think it's really helpful, and especially with the emotional support services that can be provided right now, and adding additional benefits wherever possible for emotional support. And the last thing I would say on that front too is being kind of aware of the difference between emotional support and things that can end up accidentally becoming a little bit tone deaf, such as performance boosting resiliency trainings, kind of things like that. They certainly are valuable and have their purpose, but I think right now the biggest focus that we're hearing from everyone is they really need that emotional and mental health support versus trying to just get back to their usual super achieving capacity. So that's just my plug from the humanity front in that particular space. So that's it for me. I'm happy to take any questions.
Great. Thanks, Kristen. I'm going to go ahead and have us turn to Kate Watkinson Wright and her presentation that deals a little bit more on the legislation. And so for all of our folks attending, Kate's outline is shared in the handout section, which is on the right-hand side of your screen. If you go down to the document that's called Watkinson Legal and Catalyst Law, that is the outline that Kate put together, and you can follow along there. So Kate, I'm going to turn it over to you, and thank you again for jumping in at the last minute to help
Thanks
out
for having
today.
Me. My name's Kate Watkinson Wright, and I operate a solo law practice called Watkinson Legal, and I specialize in employment law advice and counseling. I represent a lot of employers, mostly small employers, and I also represent individuals with their employment issues. I did decide to fill in at the last minute this morning, I think it was, or was yesterday. So I threw this outline together pretty quickly, but it was basically all the high points from mass client emails I've been sending out. And then I've been getting a lot of questions from clients, employer clients, over the last month approximately, ever since this FFRCA emergency paid leave requirement came into effect, and especially since the March 23rd stay-home order by Governor Brown. Everything just lit up then. So I'm going to try to make note of some of the most prevalent, frequent questions that I've gotten from my clients and kind of hit those as I go through my outline. And then if you have any questions, feel free to send them to the chat or ask me at the end. So you already know there's this new legislation that Trump signed into law, became effective April 1st, the Families First Coronavirus Response Act. And it contains several parts, but the two I'm going to talk about are the family leave and the sick leave portion. I guess the third would be the tax credit. And these were designed to support employees of small businesses. These laws apply to all companies and nonprofits with fewer than 500 employees. So every single one of my clients is subject to this law. And even if you only have one employee or two employees, this law applies to you. So it grants two types of leave, one sick leave, and one is what I would call emergency family leave. The initial draft of the legislation had both of the leaves covering all the same things, and it was pretty confusing. And what they did with the final bill is they kept all the sick leave reasons under sick leave, and they made the family leave version just childcare related. So that was nice, because if they had rolled it out with both types of leave, having both sets of circumstances, it would have gotten really confusing. So the sick leave is up to 80 hours of paid leave There's 6 types of reasons that you can take leave under the sick leave law. You need not work for your employer for any specific period of time. So on your first date of hire, you're eligible. And if you actually, I'll talk about sick leave first, which is on page 2, number 2 of my outline. And what I wanted to point out is there's 2 different rates of pay for sick leave. If you take leave for one of the first 3 reasons in Part 2C, then you get your full pay for those 80 hours. If you take it for one of the bottom 3 reasons, which basically relate to caring for someone else who's sick, you get 2/3 of your pay. In the first circumstance, you're capped at $511 per day if it's your own illness or if you're caring for a child. If it's for the bottom 3 reasons, such as you're caring for someone else, the 2/3 pay is capped at $200 per day. Part-time employees basically get a pro rata amount of hours over a 2-week period, and it's based on your regular schedule. There are formulas in the regulations that address how much leave someone would get if they have an irregular schedule. The regulations are pretty lengthy, and they actually address many, if not most, of the questions that came up when the statute came out. So it's pretty easy to find your answers there for most things. The other thing about the paid sick leave, and this also applies to the family leave, there's no payouts required at separation of employment. You can't carry the leave forward. Everything ends at the end of this year. And once you use the leave, you have no more leave rights. So I'm going to go back to the family leave, which is on page 1. And this one's a little more difficult to administer. It takes a little more analysis sometimes. What you've got right now, what's happening to a lot of us, I have 2 small children, and a lot of people are working at home with children, or they have children at home all of a sudden who require care, and so they need to be gone from work. Or they might be working from home, but the kids are there. So this leave would provide assistance for those type of employees who need to take time off. There are eligibility requirements in this portion, but they're pretty minimal compared to the usual FMLA. Now, the usual FMLA applies only if you have 50 or more employees, and an employee has to actually work for the employer for a whole year before they're eligible. That's out the window for this. You only need to work for your employer for 30 calendar days to be eligible for this leave. And you can use it as long as you can certify, and here you're going to have to rely on an employee's personal statement, certification, which is typically going to be an email that says, I need this leave and here's why. So they need to be able to certify that there is no one suitable available to care for their minor children. They need to provide the names of the children, their ages, the places of the schools or the places of care that are closed or no longer available, and then a personal statement that certifies that no one else is available during the times requested. So a frequent question I got from several of my clients was, well, you know, I've got employees working at home and they've been working, because if you'll recall, the stay-home order happened March 23rd, and then we had over a full week where this law wasn't effective yet. And people had already started working from home even before March 23rd. And so employers were asking, well, when this law comes around, if I know an employee has been doing their work, do I have to start giving them leave on April 1st? What do I do? And basically, the regulations are very clear that an employee has to be unable to work or telework. So if they're working at home in whatever capacity you notice as an employer, either they're responding to emails, they're logging hours, and they're actually working, then they're not eligible for this leave. They have to be unable to work, which means they have to actually not be working. And that's going to be an individual conversation with each of your employees. The DOL has encouraged employers and employees to be very cooperative in implementing these leave rights. One of the big questions that came out before the regulations was, can this leave be taken intermittently, which means in chunks as opposed to in one continuous 12-week period. I didn't mention 12 weeks is the maximum amount of this emergency family leave that you can take. What the regulations were very clear about is that it can be taken intermittently, but it has to be agreed upon by both the employer and the employee. So the employer can't force it, neither can the employee. The employer can't mandate it, and neither can the employee. They have to agree. And so for a lot of employers, that's a solution that has worked, because you have employees who are working from home, and maybe their spouse is working from home, and they are sharing the responsibility. For instance, my husband today is he's teleworking from home, but he has the children. So I know he's not getting a lot of work done, but I'm here at my office actually getting work done. So as an employer, I would just encourage you to be flexible and fully transparent with employees who need this leave, and try to figure out a situation that works for everybody. You do have to reinstate employees who take this leave. You, just like under FMLA, you have to bring them back to their same or equivalent position if the same position doesn't exist upon their return to work. There are some exceptions written into the law if you have fewer than 25 employees. And those basically apply if, when it's time for the employee to come back to work, their job is gone, or operations have fundamentally changed because of the pandemic, such that they don't have a position to put the employee back in anymore. And in those kind of circumstances, there is an obligation, I think it's for a year, that the employer has to reasonably attempt to bring the employee back, keep them notified, and that sort of thing. So you're not off the hook completely, but if you have fewer than 25 employees, their reinstatement obligation is somewhat more manageable than if you have more than 25. Also, something I've gone over with a few clients, you may have heard this emergency FMLA has a small business exemption. Now, there is a small business exemption. It is outlined in the regs, but it has not been tested, obviously, in any type of forum or by any agency. So we don't know how stringent the Department of Labor is going to be in interpreting this exemption, but I'll tell you generally what you have to show to claim it. And again, this will only apply to family leave. If an employee needs to use sick leave for an illness-related reason, that could be their illness, their symptoms, or the illness or symptoms of a family member, or a stay-home order, then there's no exemption from that requirement. But remember, that's only 80 hours or 2 weeks. So the small business exemption for the family leave, i.e. childcare portion of these leaves, is that you have to be able to show that granting this leave would jeopardize the viability of the business as a going concern. Well, what does that mean? I don't know. For each company, it's different. But they give you 3 reasons that if you meet any one of these, you can claim that this circumstance exists. One of those would be if the small business's expenses and financial obligations were to exceed their available resources, and the business would cease to operate at minimal capacity. The second would be if this particular employee was absent, it would cause a substantial risk to the financial health or operational capabilities of the business because of specialized skills, knowledge, or responsibilities. I'm thinking, what's an example of that? Let's say you're a small company and you're in the middle of a refinance or of some type of big financial transaction, and the CFO wants to take leave for 12 weeks. And that person is essential to doing this piece of business that will enable the business to continue. I would say that's an extreme example, but that would probably qualify. The last one is if you can show that there aren't enough workers who are able, willing, and qualified and available at the time needed to perform the services provided by the employer. and that these services are necessary for the small business to operate at a minimal capacity. This example came up with a client recently who operates an essential services type of category. Think stuff that you need to keep your house functioning. Think electrical, plumbing, that type of thing. This is a 24-hour service business, and they had an employee who works the only dispatching shift of a certain segment of the day. And this employee asked to be gone for 12 weeks. And if this person were to be gone, they would have had to literally shut down about 25% of their business. And the amount of time and investment and so forth that it would take to not only locate, but train an employee was totally unreasonable. And so I advised this client, if you document this properly, I think you can claim this exemption. Now, practically speaking, like I said, this isn't tested. And so we don't know how any of these determinations would come out. But that option is available. And I think the smaller the business, the more important to the employee, the more likely you can rely on that if the employee wants to be gone for 12 weeks. I imagine for a lot of nonprofits, that might be the executive director wanting to just be gone for this long period of time. Let's see. Talked about documentation. On the sick leave portion, it's important to remember documentation. If you're used to the Oregon sick leave requirements, that has a very light to zero documentation requirement, meaning you can't ask employees for documentation of sick leave until they've been gone for a long time. If someone wants to use sick leave under this emergency law, they do have to provide some type of documentation. They don't have to show that they've been to the ER or been to the doctor, but they have to show that they've at least sought medical care for their symptoms. Or if their leave is to care for an individual who has symptoms, they need to provide documentation that that individual sought care. And in these days, that's probably, unless your symptoms are severe, that's probably going to be some type of telemedicine or call-in of some kind. And that would be sufficient. Important to talk about existing PTO policies if you have any. You can allow employees to use existing PTO if they want to. Let's say if they're taking a leave where they only qualify for 2/3 of their pay, you can allow them to take available PTO to get them up to that 100%. That is totally your option, but it is not required. And one thing to keep in mind there is that the tax credit, which I'll talk about in a little bit, will not be available for any amounts that employees receive that's in excess of these maximums. So you won't get a tax credit for that little bit of PTO that you let them use. And if they have existing PTO, you can't require them to use it first. You have to let them use these emergency federal leaves first. And then if they finish using those leaves and they still have PTO available, you have to let them use that at that point. I'll talk briefly about tax credits. So what makes this doable for most employers, especially these small ones who would not otherwise be able to pay for these leaves, is that the IRS now has regulations that are implementing tax credits dollar for every dollar that gets paid under these leaves. I believe, and I would need to double check, that it's also going to include payment of healthcare premiums, but I'm not sure. And the credit is refundable even if, so it's based on your payroll tax liability. I don't know logistically how the refund is getting actually claimed and received because I haven't had any clients go through that process yet. But the IRS website is supposed to have the most up-to-date information processes in order for employers to claim those tax credits as soon as they spend these dollars. One way that it was listed is that an employer can basically pull money from their own payroll tax reserves that they've been setting aside quarterly and pay themselves that money, because the tax credit operates by an offset against payroll taxes. If you pay out more in leaves than you have in payroll tax liability, you get the excess back. It's a refundable credit. I hope that getting these credits is as easy as the IRS and the federal government have claimed that it would be. But again, I don't have any anecdotal comments on that yet. I'll touch on Oregon laws, which are good not to forget about. The paid sick leave under Oregon state law still applies. And so there's legal requirements around that on non-retaliation, reasons for taking leave. You might have a circumstance where there's a leave covered by Oregon sick law that is not covered by the emergency federal legislation. So you might have cases where you need to look at whether one or the other applies. If they both apply, then they can both count. But it's important not to lose track of those requirements. For instance, if you want to claim the small business exemption, you still have paid sick leave requirements. Another thing you're still going to be subject to if you have 25 or more employees is the Oregon Family Leave Act. And one thing that came up was really unfortunate for a client, not for the employee, but for them, is they were going to claim the small business exemption with a key employee. And I told them, double check your numbers. Because they were hovering around 25 for the last couple years, they ran their numbers and they realized they were subject to the Oregon Family Leave Act. And so even though I think they could have established a small business exemption and denied this request for 12 weeks of leave, they ended up having to grant it because they were subject to OFLA. And the reason they can claim OFLA right now is that BOLI enacted an emergency temporary rule in mid-March that made the Oregon Family Leave Act cover a child care related absence or a school closure absence. Previously, OFLA specifically did not cover leave, and now it does. And I think this temporary rule is only good through the end of the summer, but that's something to keep in mind if you're over 25 employees. So that's talk about on legislation. What's been coming up more lately are return to work questions from my clients because the people are anticipating these stay home orders to start loosening up and people coming back to work. And so my clients are asking, well, what can we do to keep everybody safe? And the answer to that is this is changing all the time. So if you're an employer bringing employees back, you should stay very up to date on CDC and OSHA guidelines. But for the time being, as far as I know today, because we are still under pandemic conditions, we're still under the stay home order, the EEOC has provided guidance of medical examinations and medical inquiries for employees coming in the door. So one thing you can do right now is you can screen employees' temperatures. You can ask them about their symptoms for them to come into work. You can adopt regular infection control practices. You should be doing this anyway, but you certainly can. You can send employees home who are displaying symptoms. Now, what symptoms, what questions? This is where you need to stay up to speed on CDC, World Health Organization guidance on what are the identified bundle of symptoms of COVID-19, and to not be asking outside of that symptoms. So temperature, you can ask about symptoms, but there are some key points here. You need to do this with everybody. If not every single person, it needs to be everybody within a same job category. So maybe there are certain employees who never come into contact with another employee or the general public, maybe they would be in one job category. But for the most part, you're going to be screening everybody with the same requirements. That ensures or protects the employer against claims that your screening practices are discriminatory or that they are designed to identify employees with disabilities and screen them out from work. That's the sort of crux of all of this EEOC guidance on medical examinations and inquiries, because these are covered by the ADA, and typically they are not allowed unless there's very specific circumstances. And this pandemic is one of those circumstances. So temperature screenings, asking about symptoms are okay. But if you do these things, you need to keep records. Those records need to be treated just like any other confidential medical information of an employee. So they need to be kept in a separate, locked, confidential file. And then the information needs to only be shared with those who need to know. And that's a really small list of people. The kinds of issues that have come up for employers that are still operating and thinking of reopening is, well, we just heard from so-and-so that their roommate tested positive for COVID, or so-and-so just told me that they have symptoms, and what do we have to tell everyone else? Do we have to tell all of our other employees in the workplace about this? Now, an employer has an obligation to provide a safe workplace that's free from known hazards. That is a state law, and it's also a federal law. So yes, if you know that an employee has likely or even possibly become exposed to a known hazard, you are obligated to inform that employee, but you're not obligated, and you should not identify the identity of the person who is the source of that. Now, practically speaking, there'll probably be a lot of circumstances where an employee will be able to put 2 and 2 together, but that doesn't mean you tell them. So you don't reveal anyone's identity. Even though you might realize employees can figure this out, you give only as much information as needed to notify the employee that they might have been exposed to a hazard or to someone with COVID. And then you really need to leave it at that. And the EEOC guidance might be changing on this as conditions change. So I'll be keeping up to speed on those changes. But for now, I would say the rules are a bit more permissive than we're used to in terms of employers having a conversation with their employees about their health. Typically, that's kind of a taboo subject unless the employee brings it up, because it's too risky to get into those areas because you can be violating the law. I think that's all I have in my outline, so we can turn it over to questions if there are any, but that's all I've got. And I don't see Kate.
Thank you so much, Kate. We did have a few questions. I'm here. Can you see me? Thank you so much. That was really great. We really appreciate it. We do have a few questions. I also am mindful of the time. We're coming up on 4 o'clock. So I'm happy to continue this going as long as we have, we've only got 3
Kristen,
questions, and we may get some additional ones as we go through.
Oh, okay. Do you think we should go through the questions that showed up in the chat since something happened to Kate?
Yeah, that sounds great. I think you're just saying there's only 3 questions that came in so far, so I think we have time to jump on those.
Okay.
Kristen, are you able to hear me?
I can
Apparently
answer
the
the
2
one on the
Kates
bottom.
can't
I
hear
already
each other.
answered, talking about implementing regular infection control practices. Can employers require wearing a face mask? Yes, you can require that. And if you have an employee that has a specific disability-related accommodation that is impacted by this requirement, that needs to be evaluated on a case-by-case reasonable accommodation basis. But yes, generally you can do that. The question above, I can also answer. We offer paid 2-week family medical leave as part of our benefits. For own medical or a family member, will we need to offer an additional 80 hours under emergency sick leave? Yes. And you would have to allow the employees to use that first, as long as their injury or illness or circumstances qualified under the federal emergency sick leave. Do you want me to answer?
And then there's another question
about
there.
The CARES Act, can a furlough employee applied for unemployment? The answer is yes. Oregon has enacted, like a lot of areas, a set of emergency temporary rules that deal with unemployment applications during COVID. And essentially what those rules do is they relax or redefine the standards for eligibility in COVID-related situations. And in order to discourage employees from being out and about, working and searching for work, the temporary rules redefine what it means to be available for work or disqualified from benefits and that sort of thing. So a furloughed employee can apply for unemployment just like a terminated employee or a laid off employee.
So I think Kate Watkinson Wright can't hear me for some reason, but for those of you on the web call or on the webinar, I'm going to just, are there any further questions? Go ahead and type them now. And if not, I'm going to sort of give our closing, but please don't hesitate to get in contact with any of us if you have further questions. So I just want to remind everyone one more time that this was not intended to be giving legal advice, and that Catalyst and Kate Watkinson Wright are not your lawyers unless we have an engagement agreement.
Well, I don't know where Kate is, but I have another thing I just thought of that has come up a lot that I could talk about, and that is employees refusing to work. I've had a lot of clients call me and say, this person is refusing to come to work. They say they're going to stay home and ride this out. What do I do? Do I have to lay them off? Can I terminate them? And the short answer to that, before this Coronavirus Protection Act came out, was the recommendation I made was let them use all their PTO, and if they don't have any, they're terminated. They are refusing to come to work. If they have sick leave, they can use it. If they have paid leave, they can use it. But there really wasn't a lot of option. Some clients wanted to lay their employees off who refused to come to work. But the difficulty I had with that advice is that if there's work available and the employee is able to perform it, then they're not being laid off. They're refusing to work. Now that the FFRCA, this emergency act, is out and we have the stay home order, my advice has been they can use up to that 10 days for the stay home order. So the stay home order fits into one of the first three sick leave categories under the emergency sick leave. And they don't have to provide any documentation. As long as Kate Brown's order is effective and in place, they can refuse to work for up to those 80 hours and get their full pay. But the question is, what about after that? So a lot of employers have been furloughing or terminating those employees, and it's really their option. But if the employer is going to rehire somebody to take the place of an employee who is refusing to work, that does not quite fit the characteristic of a layoff from an employer standpoint. But these are just very frank conversations that you need to have with your employees. And the key question or the key issue that you're going to need to discuss with them is, will there be a job for them when they're ready to come back? And if you're a small business and you need to operate and there's no protected leave rights remaining and the employee does not want to come into work, I think it's difficult for an employer to promise them that there will be some job waiting for them if and when they're ready. And if they don't have any leave rights available, the employer is not obligated to hold a job for an employee who wants to stay home and ride this out, as understandable as that might be. But each situation is unique. So I would recommend, if you have one of those come up, that you seek advice from a trusted advisor to help you make sure you're checking off any obligations that you might have.
Thanks so much, Kate. And thanks so much, Kristen, for joining us today. I'm going to put everybody's contact information in the chat so you know how to reach any of us. Remember that unless you have engaged Catalyst or Watkinson Legal, we are not your attorneys. But please keep us in mind if you have any further questions on this or anything else related to COVID. We're here to help.
Thanks, guys.
Thanks so much.
Hi, guys.
Hi.
Hi, are we off?